The Secret Barrister, Fake Law, The Truth About Justice in an Age of Lies. Dive into the world of fake law, The Truth About Justice in an Age of Lies by The Secret Barrister, and discover how our notions about justice are often misled by sensationalist headlines and misinformation. This summary will guide you through English law on personal defense, children's welfare, compensation for personal injury, the nuances of human rights, and the equality that law seeks to provide to every individual. Packed with enlightening examples and real-life cases, this summary will help you grasp the underlying principles of the legal system and debunk the myths that have developed around it.
Home defense myths debunked. A common misconception is that innocent homeowners defending themselves are treated like criminals under English law. In reality, self-defense is entirely legal, provided that it fulfills two essential criteria: a genuine belief that force is necessary to prevent harm, and a proportionate response to the threat. The infamous case of Tony Martin, who shot and killed an intruder, did not meet these criteria, as he acted as judge, jury, and executioner rather than genuinely defending himself and his property. Delving into the contentious case of Tony Martin, the farmer convicted of murder in 2000 for shooting an intruder breaking into his home, a common myth suggests that homeowners defending themselves are treated like criminals. However, under English law, self-defense is permissible as long as it satisfies two crucial criteria. Foremost, those defending themselves must genuinely believe that using force was essential to protect their safety. It is not important if this assumption was accurate, only that the individual thought their life was at risk at that moment. For example, if someone injures a person brandishing a weapon only to later discover it was a harmless object, they could still claim self-defense given their sincere belief of imminent danger. Furthermore, the homeowner's response to the threat must be proportionate. Upholding self-defense will become challenging if there is a significant disparity between the perceived threat's extent and the subsequent reaction. This principle is illustrated when an altercation involves a minor slap, but escalates to gunshots. In Tony Martin's case, he did not meet either criterion, which led to his conviction. He claimed he confronted the intruders, but the facts revealed a darker truth. Martin anticipated their entrance, armed himself, and then strategically cornered the intruders to shoot them. Martin's actions were not only premeditated but also employed excessive and disproportionate force. Conclusively, Martin's conviction was not a result of the law's bias against homeowners but due to his failure to fulfill the necessary self-defense criteria. Dispelling this widely held myth can ensure homeowners understand their rights and the limits of self-defense. Prioritizing child's best interests. Charlie Gard, a 2-month-old infant, was diagnosed with the rare condition mitochondrial DNA depletion syndrome, MDDS, that left him dependent on a ventilator, effectively blind, deaf, and immobile. His doctors recommended ceasing ventilation, while his parents desperately wanted to try an experimental treatment in the United States. The courts weighed in, deciding that the welfare of the child should come first. This was not the first time a child's best interests took precedence over parental desires, as demonstrated by a 2005 case involving Jehovah's Witnesses refusing a life-saving operation for their child due to religious beliefs. Upholding children's rights and protection has been a central aspect of English law since the mid-20th century, ensuring that their best interests are always considered first. Charlie Gard's heart-wrenching story began when, at just 2 months old, he was diagnosed with the rare mitochondrial DNA depletion syndrome, MDDS. As days turned into months, Charlie became a permanent resident at Great Ormond Street Children's Hospital, entirely dependent on a ventilator. Tragically, he was effectively rendered blind, deaf, and immobile with severely abnormal brain function. His doctors, evaluating Charlie's grim quality of life, recommended discontinuing ventilation. However, Charlie's distraught parents could not accept this. They discovered an experimental treatment in the United States and wanted to give their son a chance. This prompted a difficult court decision to determine whether Charlie should travel for treatment or pass away in England. Throughout the emotional case, English law maintained its unwavering commitment to prioritizing the child's best interests. Those observing the case closely noted global outcry and opinions, including comments from Pope Francis and Donald Trump. Many felt that the parents should have the final say in Charlie's treatment. Despite these arguments, history demonstrates that English courts have consistently advocated for the welfare of the child over parental preferences. In 2005, a child's life was saved due to a crucial surgical procedure despite their parents' religious objections. As in Charlie's case, the experimental treatment was unproven in humans, previously only tested in mice. The primary focus on the child's best interests has provided a foundation for children's rights and protection in English law since the mid-20th century. Even in profoundly sad and challenging cases, such as Charlie Gard's, the law strives to ensure that the child's welfare remains at the core of every legal decision. The intricacies of personal injury law. The perception that individuals can easily profit from minor incidents has contributed to a distorted view of personal injury law. In English law, there exists a duty of care that individuals must uphold to ensure they don't cause harm to others. When this duty is breached, claims for compensation can be filed. However, determining the appropriate amount of compensation takes into account the pain, suffering, and financial implications faced by the victim, painting a clearer picture of the reasoning behind seemingly outlandish payouts. You may have read about incredulous lawsuits in tabloid newspapers, such as a child being awarded £6,000 for being splashed by custard or a cleaner receiving £9,000 for tripping over their own mop. It's essential to examine these events through the lens of English personal injury law to understand how such large sums of money can be awarded. In essence, English law mandates that citizens maintain a duty of care towards each other. This obligation extends to any activity carried out by individuals, employers, or service providers, ensuring they act with reasonable foresight to prevent causing harm to others. When this duty of care is violated, such as a factory owner failing to provide adequate safety equipment, resulting in an employee's injury, the law deems it a breach. Compensation for such personal injury cases depends on several factors. The court considers the pain and distress endured by the victim, the immediate financial ramifications like lost wages and medical bills, and the long-term consequences, such as reduced ability to work. The seemingly outrageous compensation figures often fail to consider that these injuries can have a lifelong impact on the victim. Take, for example, the child who was awarded £6,000 for being splashed with custard. The newspaper reports failed to mention that the custard was scalding hot, leaving the child with a permanently scarred face. Considering this, the compensation awarded serves not as a windfall but rather as a form of justice for the victim's genuine suffering. Human Rights Act misconceptions. The Human Rights Act, often accused of championing dangerous criminals, is pivotal in protecting everyone's fundamental rights, including those who have committed crimes. It emphasizes the human aspect of criminal cases, considering individual rights and the implications for their children when making judgments. The Act is not defending criminals, but rather acknowledging their humanity and the impact of their situation on their dependents. It is common to hear that human rights are significant, but what happens when human rights law seems too lenient? Take the case of Mohammed Ibrahim, an Iraqi national living illegally in the UK who was convicted of traffic offences that resulted in the death of a 12-year-old girl. Once released from prison, the UK government sought to deport him, but a judge ruled this would breach his human rights. The claim is that the Human Rights Act supports dangerous criminals. However, a closer examination of the UK's human rights law reveals different intentions. The Human Rights Act 1988, based on the European Convention of Human Rights, guarantees every individual basic human rights, such as the right to life, freedom from torture, and freedom from discrimination. The controversy surrounding the Human Rights Act arises from the right to a family life protected by Article 8. This article allows non-British nationals to contest deportation orders if they have family in the UK, arguing that deportation would deprive them of family life. This appeared to be a factor for Ibrahim, who had 2 dependent young children. Critics typically fail to recognize that courts consider not only the claimant's rights but also their children's rights. If Ibrahim had been deported, his children would have lost their father and been negatively affected. Although situations like Ibrahim's are multifaceted and spark disagreement on the adequacy of justice, the Human Rights Act doesn't pick sides with dangerous criminals, it recognizes criminals as people and parents, deserving of certain fundamental rights. Balancing justice and fairness. In the English justice system, victims may sometimes feel underserved due to the burden of proof lying with the prosecution and the high standard of evidence required, making it difficult to attain convictions, particularly in cases where evidence boils down to one person's word against another. However, these stringent requirements are in place to protect the innocent and ensure that law-abiding citizens do not face conviction based on weak evidence or unreliable testimony. The unfortunate truth about the English justice system is that not every victim of crime may receive a satisfying outcome in court. Picture a rape case, where a victim endures the harrowing experience of giving evidence under scrutiny, only to see their attacker walk away acquitted. In such situations, the legal process may feel heavily biased against the victim. This feeling of imbalance arises from the principle that the prosecution must prove guilt, while the defendant is presumed innocent. Establishing guilt goes beyond mere persuasion, the jury must be convinced beyond reasonable doubt. For the victim, this means their credibility, character, and account of events will likely face fierce challenges from the defense. Consequently, cases resting on conflicting testimonies can falter due to insufficient evidence to satisfy the high standard of proof. Though it might appear unjust, there are compelling reasons behind this approach. If the defense had to prove innocence instead, this could lead to convictions of innocent people, as proving a negative is often an unattainable task. Furthermore, lowering the standard of proof could result in convictions based on weak evidence and unreliable witness accounts, potentially destroying innocent lives. The stringent evidence requirements in the justice system attempt to strike a delicate balance, minimizing wrongful convictions and preserving the integrity of the system. Although this might mean some guilty individuals avoid punishment, it also intends to protect law-abiding citizens from facing unwarranted persecution. The question remains whether sacrificing absolute justice might be the price of safeguarding innocent lives. Equality under the law. Sir Fred Goodwin, former chief executive of the Royal Bank of Scotland, faced intense public scrutiny in 2008 after the bank's bailout and his £700,000 annual pension. The government intended to stop his pension, but this contradicted the principle of equality under the law. Regardless of public opinion, all individuals have the right to be treated equally, and the law should apply uniformly without bias. In 2008, the people of Britain found themselves furious with Sir Fred Goodwin, the ex-CEO of the Royal Bank of Scotland. His poor decision-making led to the bank's disastrous downfall, necessitating a government bailout at the taxpayers' expense. Upon his resignation, the media discovered he held rights to a £700,000 lifelong annual pension from the bank. Sir Fred Goodwin quickly became a public scapegoat, with even government ministers like Harriet Harman, the then leader of the House of Commons, claiming that although Goodwin's contract was legally enforceable, it was not acceptable by public opinion. She boldly announced that the government would ensure Goodwin did not receive his pension. While the popular outrage against Goodwin was rampant, the very idea of denying him his pension based on public sentiment goes against one of the foundational principles of modern justice, equality under the law. Law practices, dating back to the 13th century Magna Carta and solidified by the Bill of Rights in 1689, have established that the law must apply to everyone without exceptions, including prominent individuals such as kings and queens. This principle of equality also extends to individuals who face severe public disapproval, like Sir Fred Goodwin. Public opinion may condemn him for arrogance and deem him undeserving of his pension, but it does not invalidate the legal binding of his employment contract. In a society that upholds true justice, all individuals are entitled to the law's protection, regardless of their sex, race, religion, politics, or popularity. Debunking Brexit's judicial drama. In June 2016, over 17 million British citizens voted to leave the European Union, an unprecedented event in the nation's political history. However, the victory of Eurosceptics was briefly hampered by 3 High Court judges ruling that the government must first hold a parliamentary vote to proceed with the withdrawal process. Contrary to public outrage and media portrayals of their decision as undemocratic or politically motivated, these judges were actually ensuring proper legal procedures were followed. Fake law and its consequences continue to impact society as Brexit unfolds. In the aftermath of 2016's historic Brexit vote, the UK government's planned exit from the European Union faced a surprising hurdle. 3 High Court judges ruled that government couldn't proceed as intended. These judges expressed that a parliamentary vote was necessary to move forward with Brexit, a decision that didn't halt the process but ensured its compliance with the UK constitution. Despite misunderstandings and angry headlines accusing them of being enemies of the people and hindering democracy, the judges were merely upholding the required legal procedures. The case against the government's Brexit approach was initiated by activist Gina Miller. She and her legal team argued that the UK government lacked authority to commence Brexit without consulting Parliament. Ultimately, the High Court agreed with Miller's position, stating that the consequences of EU withdrawal were significant enough to influence UK domestic law. In accordance with the British Constitution, alterations to domestic law must be reviewed and approved by Parliament. Rather than sabotaging Brexit, these judges provided valuable insight into the correct means of achieving it. This scenario wasn't a matter of political bias, but instead a fundamental legal issue. Unfortunately, many individuals and media outlets inaccurately labeled the judges' actions as intruding on politics, perpetuating false narratives that further divide the public. 2 months following this ruling, Parliament authorized the initiation of the withdrawal proceedings, and Brexit was finally underway. Although many were relieved to see progress, the legal community remained increasingly concerned about the impact of such a divisive and anger-fueled response to the judiciary's role in defending the law. The presence of fake law and its far-reaching consequences have become more evident as Brexit advances, highlighting the necessity of clear, fact-based communication in understanding the complexities of political and legal processes.
In conclusion, fake law. The truth about justice in an age of lies is an eye-opener that has given us a clear understanding of several key legal principles. Through the book summary, we unraveled the misconceptions around self-defense laws, principles in deciding the best interests of a child, the reasons behind compensation cases, the Human Rights Act, and the foundation of equality in legal treatment. This summary has showcased the importance of understanding the entire picture behind a legal matter, rather than simply believing in the sensationalist headlines which promote misconceptions. Remember, seeking knowledge in such matters is indispensable for forming an educated opinion about the functioning of our justice system.